Hello and welcome to InFocus. I'm G. Sampath. All of us like to take pride in the fact that India is the world's largest democracy, and justifiably so, we take pride in that fact. And one of the defining features of democracy is regular elections, wherein every citizen gets a say in who gets to represent them in government, who gets to represent them in the parliament. And this happens through voting. And yet, from 1951 to 2024, there have been 26 times when a person has become a member of parliament or an MP in the Lok Sabha without a single person voting for them. And this is a fact from a petition filed by the legal think tank Vidhi Centre for Legal Policy, which has taken this matter to the court, wherein it has said that those cases where a person stands unopposed from a constituency gets automatically elected. This is the law as per the Representation of People Act section 53(2). And this petition from this legal think tank argues that this is unconstitutional. Why? Because the voter doesn't have a say. So if you have a constituency and all such cases where you have just one candidate standing, that person gets elected automatically without anybody having to go and vote. And this flies in the face of the 2013 order of the Supreme Court, wherein, while hearing a PUCL petition, it ruled that NOTA is a fundamental right. The right to cast a negative vote is a fundamental right under Article 19(1)(a) of the Constitution, and therefore it should be protected. And that's how you have that button in the EVM for NOTA. Now, if you're not going to have an election, then the citizen will not be able to exercise this right. Probably it's not a fundamental right, it's a right. So is this something that should be struck down, this provision in the Representation of People Act? The Election Commission seems to think it doesn't really matter because this is pretty rare. There haven't been too many cases where candidates stand unopposed and get elected. It's been only a handful of times. And yet, as per this petition filed by Vidhi Centre, there have been, I think, 82 lakh voters, if not more, who have never had a chance to vote because of this particular aspect of the law. So to discuss this, the pros and cons of this, and whether the Supreme Court, which is currently hearing this petition, what are the various aspects it is considering. For example, one of the things which the Supreme Court bench said is that maybe in cases where there is just one candidate, you could have a minimum requirement. Maybe that person should have 25 or 30% or 15% of the vote in order to be considered as elected, rather than just getting automatically elected. Would that be something feasible? So there are many questions around this issue. And joining us today is Arghya Sengupta from Vidhi Centre of Legal Policy. He is the founder and research director there. Arghya, welcome to the pod.
Thanks, Sampath. Great to be here.
So I get to start with, I want to put to you the Election Commission's primary argument as I understand. It has responded to your petition, as Vidhi's petition, by saying that out of 20 Lok Sabha elections that have been held from 1951 to 2024, only 9 have seen uncontested election of MPs, and only one MP has been elected unopposed in the last 30 years, which happened last year from Surat. So this is so rare, this unopposed candidates getting elected, that it's not really worth the while, worth the attention of the Supreme Court, and it should be dismissed. So would you agree that it is a waste of time? Why should we really worry, given that this is so rare?
First, I think it's not that rare. While the Election Commission has rightly quoted the numbers from parliamentary election, let me give you another figure. In the latest Arunachal Pradesh Assembly elections, where there are 60 MLAs, 10 candidates were elected unopposed, without any votes. So the fact is that it's rare only when you put one part of the story. And frankly, this question is really not a question of numbers as to whether this has happened once or whether it has happened 1/6 of the time, as in Arunachal Pradesh. Every single Indian has the right to vote for a candidate of their choice. The Supreme Court itself has held that right to vote includes the right to not vote. And so that's why we have NOTA as a button. And so the fact is that even if one Indian is not being given that choice, it is something that needs not only the consideration of the Election Commission, but also that of the Supreme Court, because that is how rights operate. It's not about how many people want to exercise that right or not. It's about whether we as Indians, as justifiably, as you said, the world's largest and most vibrant democracy, as it should, in principle, ensure that every person at every election has the right to cast their vote.
Right. So your petition, I believe, is built on that NOTA judgment of the Supreme Court, right?
That's right.
And there seems to be, at least in my reading, two different or variant interpretations of what the judgment says about NOTA. Now you have interpreted NOTA to mean, as a right of the voter to which should be exercised anytime there is an election. But the Election Commission is saying that NOTA cannot be considered as a candidate in every election, and it says that treating NOTA, I'm quoting the Election Commission here, treating NOTA as a mandatorily contesting candidate in all direct uncontested elections does not find place in the statute, and the same would require legislative amendments in the provisions of the Representation of the People Act 1951. So it says that the voter can exercise their NOTA right when polling happens. If the polling doesn't happen, then the question of NOTA doesn't arise. So would you agree with that kind of
Yeah. So first of all, I'd like to say that what we are having here is a discussion on the law. It's an academic discussion. It's not meant to influence in any way the proceedings that are on. So I don't mean to criticize the Election Commission in any way in terms of its argument. This argument that they have made as a matter of law is right. But it's the law itself that we are questioning. We are not questioning the Election Commission that is doing something wrong. Not at all. As per the law, as the Election Commission has rightly said, if today there is one candidate and there is NOTA, and let's say there are 100 people who are voters, and 70 people have voted for NOTA, and 20 people have voted for the candidate, and 10 people have not voted, then what happens? What happens is that the person who has got 20 wins. Okay, because NOTA is not treated as a candidate. NOTA is only seen as an expression of your displeasure with the candidate or the candidates who are standing. So it has some moral force, but it doesn't have any legal force. So as far as the argument that the Election Commission makes as a matter of law, as it stands today, is right. But the question isn't that. The question is that is this law, as it stands, consonant with the right to vote, which includes the right to not vote for a candidate of one's choice. And our argument there is that it's not. And I think this really is not an adversarial matter, because I think any reasonable person would agree that if you have a right to say that, no, I don't want any of these candidates, and that most people have exercised that right, that means you're expressing some amount of displeasure. One, in India, people don't come out to vote. So now it shows that you have come out to vote. And you have come out to vote in such a way that you are saying that I don't like any of these candidates. Surely the sequitur, what follows from that, is that there should be some kind of repoll, whereas where these people should not be allowed to stand. That's how we should think about NOTA, and that is what our argument is, that instead of leveling down and saying that, okay, go back to the situation where we didn't have NOTA, let's level up. Let's say that if people are expressing their displeasure, let's get some other candidates. This is not against any political party. This is not against any candidate. This is really to ensure that people's franchise is meaningful.
So for that reason alone, you would say that NOTA, it is important for the voter to be able to exercise NOTA in every election, and therefore this provision of the Section 53(2) of the Representation of the People Act should be struck down.
That is right.
Right. So the Supreme Court, while hearing this case, one of the judges responded to it by suggesting that instead of striking down this section or reading it down, why don't we make some changes within the existing law so that you can require a standalone candidate, where there is just one candidate, to win a minimum amount of vote share in the election. Let the voting take place with a NOTA button and this candidate's name on the EVM, and let him or her win at least 15%, 30%, 35%, and then get elected. If that person gets 0 votes, for instance, and NOTA has got like 10,000 votes, then we will know there's nobody really, this person is not worthy of representing this constituency in the parliament or assembly. So would you what are your thoughts on this this suggestion from the Supreme Court?
So I think it's a welcome observation, and one is that this is an oral observation, so I think it should be treated as that, even if it is from the Supreme Court. It's a welcome observation that let's look at alternatives to what is the status quo. And the reason as to why we welcome it is that even if our prayer is successful and the court says that we strike it down, the fact is that ultimately some scheme needs to be put in place that what happens in case of an uncontested election. So if we were to strike it down and say that, okay, a candidate cannot be declared the winner unopposed, as the candidate is today by the Election Commission. So then how is the candidate declared the winner? Is it that the candidate has to poll one more vote than NOTA? Is it that the candidate has to poll some minimum percentage of votes? These are actually questions, and again the Election Commission is right, and I agree with them, that these are actually questions for the legislature to consider and then the executive to make rules on. So I think the Supreme Court is inviting parties, including the government, the Election Commission, and all interested stakeholders in the electoral system to come together and formulate something that works. Now, on specifically this suggestion on minimum threshold, this matter is a little bit complicated because minimum threshold of votes polled is an idea that is alien to India's electoral democracy. Because if you see that even in most elections where people are winning, most people are winning with 35%, 38%, 40%. It's broadly in that region. So we are not really counting in our first past the post system. We are not counting the quantum of votes that you get. You're only counting the relative vote count vis-a-vis your candidate.
But the first past the post system only has any meaning when there are like a number of people trying to come first. But you are the only runner in the race. There is no first past the post.
No, but that's the point. So here, it's a very good question. So then what? Do you have to just get one vote? Because in some sense, then one is past the post because the post is at 0 because you are the only runner. So the moment you start, you have to do something. Or is there a number that you must reach? Now, the thing is that the moment we put this kind of number, the question will arise that what happens in contested elections. So if you say that number is 15%, and let's hypothetically take a situation where there are 20 candidates in a poll and nobody gets 15%, and the person who gets the most votes gets, say, 13%. So what, are we going to say that person is not a winner? Surely that person is a winner. I mean, it can't be helped that the votes have been so evenly split between 10 people. So I think the point is that the minimum threshold suggestion is a suggestion whose spirit comes from the fact that the person who is winning an election must have the trust of a significant number of people to show that he has actually or she has actually won. So I think we should take it in that spirit as an invitation to deliberate further as to how we can ensure that our representatives are truly our representatives and not just the person who is standing and whose nominations were not cancelled.
Right. So what would be your suggestion, or which direction would you want to take this in terms of a solution? Suppose the Supreme Court strikes down Section 53(2), and then it says where there is one candidate only contesting, you cannot declare that person automatically elected. So what should happen in that case?
So after that, in our view, as a policy matter, what should happen is the fact that if that candidate has less than NOTA, then in that case, we should have a compulsory repoll where the person who has stood should not be eligible to stand again. So this does require some changes with the law and the rules, but as a policy matter, this is what should happen. So, for example, and this is not a solution that we picked out of the hat. In Indonesia, for example, this is exactly the system that is operational. In Colombia, a version of this system called voto en blanco is operational. So
what about advanced Western democracies? I'm not saying advanced, okay, Western first world democracies. How is it? I mean, instead of taking examples from Indonesia, Colombia, what about the bigger?
This is what I'm actually trying to show you, that newer democracies are actually much more progressive in this regard. As far as established democracies are concerned, I mean, the US, it leaves a lot to be desired in terms of how their electoral processes function. So it's very different in different states. But this NOTA type option is not there. And in the UK also, there is no NOTA type option that exists, because there the thinking is that a person who is not coming out to the polls to vote is actually a person who's exercising their conscience and not voting. It doesn't mean that they've gone off for a long weekend holiday because the vote is happening on a Monday. Okay, as we tend to think here, the person who's not voting has basically gone to, I don't know, depending on which city you live in, gone to the nearest hill station or the beach to have a long weekend. So I think that one is that so other countries have done this, and the idea there again is an extremely simple one. is that you must command the confidence of your voters. And if your voters are, you're not only not commanding the confidence, but they are actively saying that none of the above. Okay, and this is like and that's why NOTA is not. We sometimes say NOTA and get carried away with the acronym, but at the end of the day, I mean, basically, it means that I don't want any of these people who are above. So it's an active vote of no confidence. So I think that there should be a compulsory repoll, and yeah, the person who hasn't won those, who was lost to NOTA in that sense, should not be eligible to contest.
Right. No, let's look at actually how these things happen. Now we've had so far a theoretical discussion,
Yes.
an academic discussion. So now, whenever we have a lone candidate, a lone wolf contesting and winning kind of a scenario, like we had in the 2024 Lok Sabha election, I think a BJP candidate, Mukesh Dalal, won from Surat, unopposed. So there were other candidates who were contesting, and the withdrawals happened last minute. Last day, I think there were withdrawals, and it is clear that it was fairly clear that in many cases, maybe not in this case, we don't know, but in many cases, when these kind of withdrawals happen, they're orchestrated. You may have many examples from history where withdrawals have been orchestrated through machination, threats, we don't know what. So, which is basically the point is it's not really a democratic
That's right.
process which is which is at work. So, given all this, does this not mean that there is all the more reason for a candidate to prove that, for a lone candidate to prove that he is getting elected by popular vote and not through some kind of backroom deal or whatever, and therefore all the more reason that he needs to be voted in.
Absolutely. And so if you take this example, and again, this is not to do with any particular political party. So Mr. Dalal, who was the BJP candidate from Surat, there was a Congress candidate. The Congress candidate's candidature was rejected by the Election Commission. I believe rightly so, though I'm not going to comment on it because I haven't looked at it in detail. And there were several other smaller candidates, as in who withdrew. And as you rightly said, the withdrawal happened on the last day. This is not the only occasion, as in a more famous example was the former Chief Minister of Karnataka, Nijalingappa, who stood from the Shigaon Assembly constituency in 1967. And at that point of time, you remember that the Congress was in some turmoil. And this was a case that actually went right up to the Supreme Court because he was declared a winner unopposed. And there were several other candidates. And one of these persons said that there was alleged that there was someone who came and attempted to give a bribe, purportedly on behalf of the winning candidate, so that he would not stand. And there were about 21 candidates who moved aside. So the fact is that there may be some genuine cases where there is only one candidate, though just with India's population, that kind of possibility is a little bit remote. But in many such cases, this happens because of some machinations, some technical deficiencies in the application that has been filed. So, given that, and then there are many more examples of similar kinds that can be given. As you said, there were over 26 that have happened in at the central level alone. So, given that, I think that it hurts nobody to say that okay, you're contesting, an election will go on. And if an election has to go on, then three things have to happen. First is that you have to campaign. People should know what you stand for. Just because you're there and you're the only person who's there and you're winning doesn't means that people don't know what you're standing for. That's number one. So you actually have to campaign. You have to canvass. That's from the candidate's point of view.
No, but if you're the only one, then you don't have to campaign, right?
I mean, the thing is that if we had a provision where you actually have to either win a reasonable number of votes or you have to go above NOTA, then you have to do something.
So as things stand today,
yes,
you don't have to campaign if you're the only candidate
at all, because you're declared a winner. I mean, the election day may be 5 days away, but before that, you've been declared a winner. So if you see how that ticker started when those election results get announced, this time the ticker started with 1 for the BJP because Surat was already, the BJP had been declared a winner. So the fact is that if you were not declared a winner, then one is that you will have to campaign. Number two is the fact that there is people will be able to come out and actually they'll be able to think about this in far more significant, we'll give it some thought that should I vote for this candidate or should I vote for NOTA. So actually in that sense, it's making people exercise their franchise more seriously. And third is that maybe if there is one candidate for a long period of time, maybe other candidates will also come in to prevent it from happening. Okay. There is a flip side, and let's be clear. The flip side is what is always thrown at us, which is cost. And what is the point of doing this election? As there's only one candidate, you will again go ahead and do it, but you are going to unnecessarily incur cost. Now, there, as in we've done some back of the envelope calculations, the fact is that the cost of holding one extra election at the time when you're holding.
How is it extra election? We're going to hold that election anyway. The costs actually.
Those polling booths, for example. Like, the fact that you don't have to make arrangements in those polling booths. This is the argument that is made. That you don't have to, those EVM machines don't have to be used. You don't have to pay those volunteers. You don't have to make arrangements at that polling booth. You don't have to get those extra number of security
No, I don't agree about the cost argument. No, the cost argument would be where you have to spend something extra than what you would have normally spent.
That's right.
If everything is going as they should, you would not be spending extra, you would be spending what you should. But what you're going to be losing is the money you will save.
Exactly. Absolutely right. So the cost argument is one argument of savings, because you will save something. You will spend less than what you would ordinarily have allocated. But the question that we need to ask is that, yes, there might be some saving. Okay, although that number is severely debatable as to how significant that number is. But whatever, let's assume it is significant. But even if it is significant, I believe that this is a small price to pay, literally, as in to ensure that people have the right to vote. The fact of the matter is that our rights, whether it's fundamental right or statutory right to vote, is not contingent on whether the state has resources to spend for them or not. You can't say that the right to free speech is only if the state has resources to be able to provide for that. That's not how rights operate. Typically there are exceptions. But the fact is that.
So I know I said this is a fundamental right, this NOTA thing. What kind of right is that?
So basically the right to vote in India is a statutory right. It is not a right that is in the Constitution, a fundamental rights chapter of the Constitution. But the right to vote for a person of your choice, or to not vote for any persons if they are not of your choice, is a fundamental right under 19(1)(a). So maybe it's a frankly technical thing. But the fact is that my freedom of speech and expression includes the freedom to choose A, B or NOTA. That is my freedom. The right to vote itself, because it's not enshrined in the Constitution, is a statutory right. But I think we should not get into that distinction, because over a number of cases, the Supreme Court has said that this is virtually at the status of a fundamental right, so it cannot be taken away. So I think that's the settled legal position, right?
Now, let me ask you a hypothetical question. Let's say in this hypothetical future, there is a situation where this hypothetical party becomes very powerful and very wealthy, and out of say X number of constituencies, whatever, nearly all of them, it is able to buy up rival candidates, and there's only one candidate in every constituency.
That's right.
Right? So this, if it were to happen, now this present system will become completely dysfunctional, right? And we need to think about avoiding or preempting that.
Absolutely. And the Supreme Court was right. That's why in some of the oral observations that were made, that this is really a question not about a technical reading of Section 53(2) of the Representation of People Act. This is a question of the state of health of our democracy. The fact is that if we are proclaiming ourselves to be a true democracy, which is at least we are an electoral democracy in terms of the fact that voting happens freely and fairly for every 5 years for Parliament, and
even that is
it's questionable.
It is contested by some people who say that we are an electoral autocracy.
Whatever, that kind of question keeps getting raised at different points of time. I'm not an expert. I don't want to comment on that. But at least the basic fundamental proposition that if you are a working democracy is that you are holding elections on time. There is a seamless peaceful transfer of powers that is happening once the results are declared, which is done freely and fair. Okay. Now, some people may question some of these, but largely speaking, this is the basis, not even getting to the fact as to whether we are providing for food and water and internet and all that a good democracy should, but that's a different matter. But even this basic, and the Supreme Court rightly said that this question is about that basic fundamentals. And you put it well, that if in that hypothetical situation this happens, the fact is that are you then an electoral democracy? If the position of law that is there today stands and the Election Commission is right, then you still very much are a robust electoral democracy, despite the fact that this hypothetical party and its hypothetical candidates have won unelected in more than whatever 272 or whatever number it happens if we have delimitation. They have won those number of seats, and so they are in power. So I think that this is, yes, all
And more significantly, all those people in the parliament would have reached there without a single person voting for them.
and it could be anybody, right? It could be anybody. They could be anybody, and they could be anybody. And so that strikes at the heart of what it means to be a representative democracy, right? I mean, democracy fundamentally is about, and certainly indirect democracy is fundamentally about representation. That this is my voice in parliament, okay? And we know that parliament is getting denuded anyway. And I think there is a larger question in terms of the fact that we are moving to a much more executive democracy, but at least the executive is also ultimately voted by people, because they are all parliamentarians as in who are voted by people, whether directly or indirectly. So the fact is that for the health of our democracy, it is necessary that we think about this issue carefully. Yes, all this may seem gobbledygook and they may seem like some kind of unnecessary theoretical academic propositions, and I've heard of that. But this is what I mean. It sounds like with most things that first it seems like fiction and then it's true. So
Many people might think of it as too arcane kind of a discussion, gobbledygook, as you said. But I think given the broader context, not just in India but globally, with the democratic backsliding being a trend phenomenon seen across geographies and so on, I think it's not completely unimaginable that one party or entity could buy up candidates and end up with like one candidate in every constituency, whatever. Now, one final question, Argya, for before we wrap up. No, this Vidhi, this petition, it flags unopposed election. That is, candidates winning unopposed only at the Lok Sabha and the state assembly level. That is the kind of situation it is talking about. But if this, as you said, explained so well in the course of this conversation, if it is a matter of principle and democracy, should it not be extended to the other lower level elections as well, to municipal and panchayat elections? Why isn't that a part of the petition as well?
So this is a very interesting question. So, and it's also not, for once, this is not hypothetical. In 2018, the Maharashtra State Election Commission was conducting local elections in Dhule and Ahmednagar. I can't remember exactly whether it was Ahmednagar, but it was certainly Dhule. And there, they said that NOTA is going to be treated as a candidate. So if NOTA wins, then in that case there will be a repoll that will happen. Okay. Now, so it is not a matter of speculation. It has already been done and it was widely accepted, and they took it from the Supreme Court judgment. So it has already been done. It is preceded. The reason we did not include it in our petition is because of the fact that Section 53 of this Representation of People Act, which we were looking at, is a section that deals with elections to Assembly and to Parliament. So this is a different set of provisions in Article 243. That is actually provisions that are there in the Constitution itself. So we did not want this to be a basic structure issue, okay, because we feel that at this level, it is significant for our democracy, but it is my personal view, and I don't speak for everyone in the think tank, that I don't think that we should take every issue and make it a basic structure issue. I think if it can be done at the level of a fundamental right, then we should try and do it at that level. So that is the reason as to why it's not been done at that stage. One is that it has already been done in some local elections, like in Maharashtra. And second is that if there is a favorable judgment that is there in this case, then surely that same principle will apply in cases of local elections as well. So that is how the law develops, one step at a time.
Right. This is a really fascinating question, and I hope we get a good judgment from the Supreme Court. Thank you so much, Argya. That's all I have for you.
Thank you, Sampath.
In this episode. Thank you so much.
Thank you.